Doctors, the flick, and check out Doin' Time for news, views and tunes on prison issues from Guantanamo Bay to Christmas Island to prisons and detention centres everywhere. Every Monday at 4 p.m. on your community radio 3CR.
We are still fired up and we're still talking about revolution.
Hello and welcome to the Doin' Time show. This is 3CR Community Radio, 855 AM on the dial, streaming live on www.3cr.org.au. And it's approximately 4 o'clock. And Peter's here too in the studio, pushing buttons. Hi, yeah, so first up on the show, we're going to be speaking with Ian from the Refugee Action Coalition, and he will have to correct me on that because it's a real mouthful. So he'll be introducing himself presently, and we will be speaking with Ian about a hunger strike which I need to get a current update on, but apparently as of the 15th of January, hunger strike started over immigration detention visits restrictions. And over 200 detainees at two detention centres, Villawood in Sydney and Maribyrnong in Melbourne, have declared a hunger strike in protest at visiting restrictions recently announced by Border Force. The detainees have been on hunger strike for more than 24 hours of last week, since the morning of Monday, 15th of January. Posters declaring the changes would apply after 22nd of January, which went unannounced last week. And Ian will be speaking about those restrictions and policies, which are quite atrocious. Basically, just to summarise, they have to be given 5 days' notice of any visit and fill in lots of draconian 5-page forms with actual visits restricted to one-on-one. But he'll be talking about that later. And then after Ian, we will be speaking with Sophie, Ellis from the Flemington Kensington Community Legal Centre about Corina Horvath, who was assaulted by police in 1996, and she was hospitalised for 5 days. As a result of that, we will be speaking to her about some current updates in relation to court cases and trials in regards to police officers. We'll also speak to her about the human rights of the victims and the complaints that are brought to police, and having a look at some of the ways that we can improve those violations of human rights in regards to the UN and Parliament. And we're now going to be speaking with Ian. Hello, Ian. Welcome to the program.
Yeah, thanks very much. Hi.
Hi, Ian.
It's so lovely to have you, Ian, and I'm just wondering if you could just correct me on your title and where you're from.
No, you were, spot on. Yep, that's Ian Rentoul from the Refugee Action Coalition in Sydney. Yeah, it's Refugee Action Collective in Melbourne. I know that. It is confusing, but...
I was spot on. Oh, that's great.
But, I go by lots of names, but, RAC's fine.
As we all do when we're activists. But thank you, Ian. Now, I'm just wondering if you could just speak about what's happened with the hunger strike of these 200 detainees and talk about some of the background in relation to the new policies.
There's been some changes. So the people who were on a hunger strike at Maribyrnong, are not on hunger strike anymore, and quite a few of the people at Villawood, has also, come down. But some people are, it's 7 days now, are sort of sticking it out over those changes, because the changes means a lot to them. And certainly the hunger strikers brought attention to the changes, and a lot of the people, the visitors who, previously perhaps thought it was a fait accompli, have now been registering their complaints and protests at the restrictions. Because it's almost like the Border Force is trying to they are trying to make visiting much more difficult, and effectively making it almost impossible for people to be able to drop into the detention centres to see people as much as they like. So they're putting a huge obstacle to visiting, which makes no sense whatsoever.
So basically, they have to fill in a 5-page form. Is that right?
Yeah. So the first thing is they've got to give 5 days notice. So, it means if you want to see, sort of your friend or your relative, your partner, in 2 days in a row, you've got to fill out those forms and make the application, 5 days, beforehand. Now, there's very few people who know that they what they're doing in 5 days ahead. How do you make arrangements to know whether you've got to drop off the kids at school, whether you've got a sick mother you've got to see, and so you've got the first thing is the 5 days notice. The second thing is the form itself. It's 5 or 6 pages long. A lot of information needs to be provided, including a lot of information about the particular person. It's not always information that people have, their number, their date of birth, other information that people would not normally have about people who they want to visit. You've got to put down information, about yourself and criminal background, for example. So that's also, a difficulty. And then there's the question of the 100 points of identification, which may be easier for people who are, Aussies, if you like, but people who've non-English speaking, backgrounds. But even for many people who've got driver's license is only going to count as 40 points. So they're really asking for passports. Passport will be 100 points, but of course, if you haven't got a passport, they're wanting now identification of the same level for people who are, for kids who are under 16 or under. And that creates greater difficulties to have 100 points with photo ID for people who are young members of your family. So there are all kinds of those restrictions, as I said, but they're really designed to make it as hard as possible to be able to visit someone in a detention centre rather than making it as easy as possible.
Absolutely, and in fact, people who are low income, even if they are Aussies, wouldn't be able to afford a passport. And then not to mention, people with disabilities who don't have a driver's licence.
Look, there's all
non-English.
There's all kinds of people in the community who are going to find it hard to get those 100 points. That you're not going to be prior notification. You're going to have to show up at the detention centre. I know Maribyrnongs and Maida are not the easiest places to get to. Villawood's not the easiest place to get to. To spend a couple of hours travel to get to the detention centre and find out that there's some problem with your ID, some problem with the form, some reason Border Forces excluded you, is going to make that extra obstacle. And it won't take too many times of being knocked back. When it's people will be very, very tired of trying to jump through the hoops.
Yeah. Ian, also, and Peter, you could possibly comment on this if you wanted to, but I've visited Meta, and Peter also has too, down at Broadmeadows.
Yeah.
And usually what tended to happen is that we'd be able to go in and sit at a table with all the, as many detainees have wanted to sit there.
Yep.
And you'd be able to put more than one person on your visitors list and organise that. And people, you'd be able to sit down and like in the words of one detainee, he said to me, I like the way we can all sit down like a family and obviously, and eat the food. Now, obviously, when you're in prison, you can serve your time and it's not indefinite and you get out, okay? When your sentence is finished, you get out. In prison, you've got to visit one person at a time, don't you? Are they organising that there too in the detention centre?
That's exactly right. So it will be one-on-one. You'll be able to make an application to see one person, although two people can make an application to see the same one person at a time, but you can't make an application to see two people. And if that person's not available for some particular reason, you're not able to change who you can visit. So that's another issue. It means you can see one person at one time, per visit. And as you said, it will also remove the possibility of being able to interact, being able to see people relatively freely in the visitor centre.
Yeah.
And that's what it's designed to do. It's designed to make it much more like prison.
Yeah, it gets people out of their like rooms, and everyone comes in and visits in the visitor centre and enjoy each other like a family member was saying. Also, one of my friends, she was saying that she's tried to fill out an application online.
Yeah.
And there's about 10 boxes that were red that she couldn't answer. And So she couldn't visit because of that.
That's right. It's not clear whether not being able to answer some of those boxes is going to mean a rejection. I mean, when I went to Villawood, I had to fill out the form there. It was it's from the 22nd. It's meant to come into force. And I had to fill out the form there. Well, some things I just didn't know, and I didn't fill it out. I got in, but I said, at the time, whether that continues to happen after the 22nd, we don't know. I mean, I could sort of bluff my way, push my way with the person who's at the counter on that particular day to say, look, I've been visiting this person actually for 8 years. I don't know their date of birth. But you've got the date of birth on your form. I don't see why I need to know that date of birth. I know the name. You've got the name. We both know that she's in here. So how about we just go ahead with the visit and forget about this other nonsense that I'm meant to be able to provide a immigration number, date of birth, and so forth. That worked at that. On that day, but you can see quite easily that if you haven't filled in, particular boxes, you could be excluded. And you're not going to find out till you show up to visit.
Depends on which officer there is too.
Yes, but it may well mean all these applications, what I was told, they're going to go to Border Force to be vetted. So some bureaucrat is going to sit somewhere online, off-site, process these things and then send the list of who can visit to the detention centre. So the decisions are going to be made by Border Force, off-site. So there's going to be much less scope, or if any scope. And I've seen it myself. People have been, come from a long way, sometimes interstate, and have been turned away, at the detention centre because of, some, they only gave 23 hours notice and not 24 hours notice, or
it's pathetic.
Whatever, some piece of nonsense, And I think the other thing people need to understand is that these changes come along with, changes about, the ability to be able to bring food in. You talked about being able to have food and sit down, like a family. Well, some families now are not able to do that because part of the restrictions, although it's being challenged in court, the Border Force have already introduced is that it is only packaged food with use-by dates on them that are going to be able to come in. So it's ruled out the possibilities of bringing fruit, for example, of bringing cooked food, home-cooked food, of even bringing, takeaway from, sort of your favourite, restaurant or your favourite food that you might have. You can't do that anymore. You've got to bring, chips and, biscuits and, twisties.
Yeah, because I made a lentil soup and brought it in one time.
Yeah, that'll be out.
That's going to be out, so we can't bring any pieces of fruit or, any hot food warming and comforting.
It's been happening in MITA for a while.
Yeah.
It's anyway. So when does that actually go? Does that go to Parliament? Does it?
No, it's actually just a regulation which is going to be enforced by Border Force as of the 22nd. Now they say, which is what it does today.
What? So it's not even going to be debated in Parliament?
No, it's just a regulation that's going to be enforced in the same way that other regulations have changed. Like when they, even the 24-hour notice was restrictive enough, and we kicked up a fuss about that when that was introduced in, Sydney. Maybe it's a year ago now. Maybe it's not quite that, but that just. That just came in. The weight of it just came in. The changes to food. I mean, that is being challenged in court. The attempt to ban mobile phones is also being, challenged in court. But people haven't seen a way to actually challenge these visiting restrictions yet.
Yeah, look, this is just very cruel, degrading treatment. It's a violation of human rights, and Mr. Dutton is in top form, isn't he?
It's what Dutton is sort of making a particular practice of this kind of behaviour, and I said it's Border Force. Border Force is attempting to militarise its control, of the detention centres. It's painted part of, continuing to criminalise, sort of people who, whether they are, the asylum seekers who have committed, no crime whatsoever. Increasingly, they're, it's 501s, people whose visas have been cancelled, but they're people who have been before the court system, who've done their time. They should not be subjected to further punishment at the discretion of an immigration minister.
Absolutely not. Ian, thank you so much for coming onto the program. We'll be interviewing Sophie Ellis next about Corina Horvath and the deplorable assault by police, and looking at how that's going. It's approximately 4:14 and you're listening to an interview with Ian from the Refugee Action Coalition. Thank you so much, Ian. Take care of yourself.
Yeah,
Keep
thanks
up the good work.
for having me. Yep,
Thank you.
Thanks. Bye-bye.
Bye-bye. Bye. And that was Ian from the Refugee Action Coalition in Sydney. speaking about some policies and regulations that will affect and restrict the visits to detainees. And so pretty soon we're going to be speaking with Sophie Ellis from Flemington Kensington Community Legal Centre. In 1996, 21-year-old Corina Horvath was assaulted by police during an unlawful raid on her Melbourne home. Her nose was broken and a tooth chipped. She was hospitalised for 5 days. In 2001, Miss Horvath won a civil case at the county court. After 40 days of evidence, the judge found police had committed trespass, assault, unlawful arrest and false imprisonment, and awarded Miss Horvath $143,525 in compensation. This amount was reduced on appeal, and Miss Horvath was denied leave to appeal to the High Court. In Victoria, individual police officers rather than the state are liable to pay damages for unlawful conduct. Where a police officer is unable to pay, the victim can go uncompensated. Further, none of the police involved has been disciplined or prosecuted by the state. Miss Horvath seeks adequate compensation and effective discipline of the police officers involved. In 2014, the UN Human Rights Committee found that Miss Horvath's right to an effective remedy was violated in relation to the cruel, inhuman or degrading treatment, arbitrary arrest and detention to which she was subjected, and the interference with her home and privacy. The committee recommended legislative reform in Victoria and adequate compensation for Miss Horvath. So we're going to be speaking with Sophie very soon, and I took the liberty of actually quoting some material from the website, a number of websites actually, just to highlight and introduce, given that this is a very complex matter. When we speak to Sophie, I just wanted to make it clear that Sophie is no longer the lawyer for Corina. She was originally her lawyer, and the matter has been referred to IBAC. Obviously, the Doin' Time show has done extensive coverage on Corina and, in fact, recorded an event off-site where she was able to speak about it. It's taken 18 years for all this to be resolved, and it's not even resolved yet. So we'll be speaking with Sophie presently. We do have to be careful about contempt of court. We're not going to be discussing legal strategy on air. We're just going to be speaking about the update and looking at what's happening with police investigating police. But we will speak about the information surrounding Corina and what's happening with the committal and other issues. So, yeah, it's approximately 4:17, and I'm going to be lining up Corina now. Sophie now. And you're back with the Doin' Time show, and we're speaking now with Sophie Ellis from Flemington Kensington Community Legal Centre. As I said in my introduction, we're going to be speaking about Corina Horvath and speak about her background and what's happening currently. Hello, Sophie. Welcome to the program.
Hi, Marissa. Thanks for having me.
It's lovely to have you. And we've got Peter here as well, my co-host.
Hi, Sophie.
Hi, Peter.
Now, Sophie, I'm wondering if you could just talk to listeners about what's been happening with Corina, perhaps give a bit of background and then go into what's happening currently with her.
Sure, no worries. Well, Corina Horvath is a woman who over 20 years ago was actually really brutally assaulted by police when she was in her 20s. And it's a really historic case because it's been tracking through our legal system for many years. And just this week there's been some updates which I'll come to. But essentially police were attending Corina's home without a warrant. They wanted to follow up on a road traffic offence that had been committed earlier that day. This is way back in 1996. And through that unlawful raid, Corina and other occupants in the house were assaulted. Corina was knocked unconscious, had her nose broken, and was hospitalised for days as a result of injuries sustained during that raid. And I suppose Corina's case is really a case that exemplifies how our system for police misconduct and how our oversight and investigation of police misconduct is broken in Victoria, because a lot of the issues that happened for Corina, which I'll come to, are still evident in today's system. So what happened for Corina after that assault was that she was charged with, 9 offences, which were ultimately thrown out by the magistrate's court, and it was found that those offences were brought in properly by police. She went on to take a claim to the county court in Victoria seeking compensation for damages. And ultimately, in 2001, it was found that police had, in fact, committed a raft of tortious offences, including battery, false imprisonment, malicious prosecution, and compensation was awarded to Corina and other people who were part of that claim. But unfortunately, that compensation was never successfully recovered from the police defendants. What happened in that case was that the state successfully argued that they weren't liable for the tortious conduct of police because an equivalent section today applies, but essentially where the police conduct is so egregious and bad that it's basically carried out in bad faith, or the equivalent under today's law is serious and willful misconduct, the state can argue that it's not liable. And so where the award of damage is then made against the individual officers, but the officers cannot pay or they're impecunious, then the victim doesn't have a complete remedy. So that's what happened in Corina's case. And ultimately, she took her matter to the United Nations Human Rights Committee, which governs and looks at how Australia is complying with its obligations under the International Covenant of Civil and Political Rights. It's a treaty that we are signatory to, and it protects a whole raft of rights, including things like freedom from cruel, inhumane and degrading treatment, but also a right to an effective remedy, including remedies where rights are breached by officials of the state, like police officers. And finally, in 2014, the United Nations Human Rights Committee said, yes, Australia had breached its obligations to Corina because she had never received an effective remedy, and that it needed to fix the situation. And part of the reason why there wasn't an effective remedy was not only did she not receive compensation and the state didn't take responsibility for the liability of its officers, but it found that Corina didn't have access to an independent, impartial, prompt or effective investigation into her human rights abuses. And it said, the decision of the United Nations Human Rights Committee said that, in fact, this needs to occur. Part of an effective remedy is requiring that human rights breaches by police officers are independently and promptly and effectively investigated. And in Corina's case, she had made a complaint about the conduct of the officers, but it was internally investigated. And the internal investigation found that there wasn't sufficient evidence to pursue any disciplinary action against the officers. And despite the county court findings that were ultimately upheld by the Court of Appeal, that there had been tortious conduct carried out, those police officers were never disciplined. So it's really very extraordinary that a court of law can make such strong findings of fact, and yet there is no follow-through in terms of disciplinary processes, and that those officers can remain employed and on the beat, and, you know, putting other people at risk of harm.
And be promoted.
So, absolutely, yes, some of those officers were promoted. And I suppose what's going on right now is that following the UN findings, which were obviously, you know, really powerful, and a call to action for the government, the oversight body we have in Victoria now, which is called IBAC, the Independent Broad-Based Anti-Corruption Commission, initiated a review on its on Corina's case, and it was engaged a retired judge who recommended that the officer who had broken Corina's nose be charged. So that's slowly working its way through the system. And Officer Jenkins this week, and it began last week, is facing a committal hearing at the Magistrates Court of Victoria, where a decision will be made whether or not to indict him for a trial. 20 years later, criminal charges are now, I suppose, the next step in this very long and really very awful process for a young woman who was really just seeking redress for human rights protections that she should have been afforded. Yeah, that's right. So that's a snapshot of the case. It took a little while to go through it.
No, but it's really important, isn't it, Sophie?
Yeah.
And I wanted you to basically speak at length about this, which is why I didn't stop you in any way. I just wanted you to talk about it, and that was great. Thank you so much. But I'm wondering then, it's very interesting that it took so long. And just in terms of procedure, the policeman was arrested, no? Or are they just kind of doing a committal first to see?
Sorry, say again.
So the policeman was charged?
Back in the day?
No, now, currently.
The policeman has been charged, and they've been awaiting this committal hearing. I think the policeman, from memory, charges were laid last year, and because of delays in the court system, it's not until now that the committal hearing has been scheduled, and now the process will be following on the committal whether or not a trial proceeds.
Can you comment on? You mentioned before that the system in Victoria is broken, and I'm assuming you're meaning about police investigating police and, that there's no transparency. Can you comment on that?
Yeah, absolutely. So, one of the biggest challenges Corina had was in terms of accountability for what happened to her. As I mentioned before, the investigation was woefully inadequate, and this is what the UN also commented on in its decision regarding Corina's case. So, the victims were never called to give evidence, for example, and it wasn't at all victim-centred. And, of course, it was also carried out internally by police officers. And we know now from the UN decision, but also from human rights law generally, internationally, and treaties that Australia is subject to, that where there are state violations of human rights alleged by police officers, that they need to be independent, they need to be effective, they need to be prompt and transparent. And that's what we're calling on, and this still needs to occur. So today in Victoria, we do have an independent oversight body, as I mentioned, it's IBAC, but we know from statistics that the overwhelming majority of complaints that are made to IBAC about police misconduct are referred back to Victoria Police for internal investigation. IBAC does have the power to investigate police misconduct complaints, but it only investigates a very small fraction of that. Its jurisdiction is very large. It also covers public sector corruption. So it has a host of other areas that it looks at and carries out investigations into. We also know that investigations take a very long time. They can take, I've had experience as a lawyer of an investigation taking upwards of 1 to 2 years to be carried out. Very rarely charges are laid, and often redress is sought by a victim through the courts, for example, through a civil remedy by bringing an action against an officer claiming for damages, injuries and so on. So these are all signs of a system that really isn't working, and it shouldn't take 20 years to get a remedy. And we talk about that from Ken, the Horvath test, and that is if someone was assaulted like Corina was back then today, would they face similar hurdles and similar obstacles? And sadly, the answer is yes, that
Absolutely.
many of the obstacles remain. And, it's a really awful experience for many people who understandably want to see their complaint investigated by a body other than the body responsible for employing the officer that has alleged to have harmed them and assaulted them.
And she couldn't even call witnesses. Corina couldn't even call witnesses, could she? Has that changed?
No.
What's the point of having a trial then?
Yeah, well, it was an internal investigation, not a trial. So,
Yeah.
But unlike a trial where you can, call witnesses, or a civil claim where you bear the onus of proof and you can call your witnesses.
Thank you.
There's very significant flaws, and the victim doesn't have control of the process or much input or say at all in the process. And I suppose one of the other issues is there's not a lot of transparency around how investigations are carried out, to what standard they're to be carried out to. And so, the whole process can be really, I suppose, disempowering for a victim of state crime.
And basically, the victim also, and correct me if I'm wrong here, but the victim doesn't have the capacity to seek a review of that decision. Is that right?
Well, the victim can seek a review of an internal decision to IBAC, but there is an oversight body for IBAC as well. But the jurisdiction for review is relatively narrow, and a lot of the time, by the time a person's gone through that process, they feel so disempowered and disillusioned that they don't necessarily take that step.
Yeah, and so just to compare and clarify, Sophie, and thank you so much for coming on, because it is quite complex, isn't it? Bear with me here. But
that's okay.
In terms of the current trial then, obviously then Corina would be able to call her witnesses.
That's right.
Yes. So the witnesses can come.
That's so. If this is a criminal trial, so it's if the officer is in fact committed to trial, then the IBAC, which is bringing these proceedings, will have witnesses that they call, and witnesses on both sides, defence and prosecution, will be called to give evidence. Obviously, there are, without wanting to comment too much on the case, having a criminal trial, so many years later is never ideal. And this is why we say it's really important that investigations are carried out promptly as well, so that if investigations do find impropriety, then other judicial processes can, take their proper course.
Absolutely. Now, we were speaking off air today, Sophie, about the submission that was produced by Remedy Australia, which is the submission to IBAC inquiry into the external oversight of police corruption. And I found that to be a very informative submission. Wouldn't you agree?
Yeah, it was a fabulous submission. I'm very happy to talk about that. There was a submission, as you said, to this parliamentary committee's inquiry, which is currently on foot in Victoria. So yes. It's essentially a committee that's set up to oversee IBAC and how it's operating, and it's examining how police corruption and misconduct is overseen in Victoria. And one of the questions is whether or not there needs to be changes to the current system. including, investigations of police misconduct. The committee is due to report on the 30th of June, and there was a public submission process that's just concluded. But it will be having public hearings at some point, which people can look out for, because understand that you'll be able to attend. They'll be open to the public at Parliament House. But Remedy pointed out to the inquiry that there needs to be changes, and that the recommendations of the UN decision in the Horvath case haven't in fact been fully implemented. And one of the key things that needs to change, which hasn't been implemented by the government yet, despite the UN decision in Horvath, is this need for independent and effective and transparent and victim-centred investigations. And so that's what one of their recommendations is calling for in terms of Remedy's submission.
Interesting. Yeah, because I'll tell you, one of the things that really impressed me about the submission is the way that the organisation spoke about amending the Charter of Human Rights and Responsibilities Act 2006 in Victoria to include the right to an effective and enforceable remedy of any person whose rights are violated. That's right.
And I think that's, this inquiry is a fabulous opportunity for the government to really step up. And Victoria especially, we should be leading the nation on this. We do have a Charter of Human Rights and Responsibilities. And as you read in Remedy's submission, we don't have a clear right that is specifically set out in the Charter for the right to an effective remedy, including independent investigations. And unfortunately, there was a case that ran recently, Barre and Small, where this question of whether or not there was an implied right to an independent investigation of police misconduct was run, and fortunately the court found against the applicant in that matter. So there is a need to clarify the law and clarify Australia's obligations, which should mirror obligations set out under the UK Human Rights Act. So this inquiry again brings home a chance to remedy that. And interestingly, back in 2015, we had a review of the Charter, and the government did endorse one of the recommendations by that independent review that IBAC be given the capacity to investigate allegations of serious human rights abuses by police and PSOs. So again, this inquiry is a chance to put that, I suppose, agreement by the government into action and actually legislate to have, really good investigative capabilities by an independent body, which will restore, I think, public confidence in the police complaint system.
Absolutely. And in fact, the equality is not the same scheme that Victoria Police has undertaken to include human rights standards to police training. Apparently that's not ongoing. That's only for new recruits. And I believe that Flem Ken did a lot of work to get that happening. And then, of course, you've got the other recommendation from Remedy Australia, which talks about the police having human rights training, which is terribly important.
That's right, and it's really important that police, right through from new recruits to experienced officers who have been in the force for many, many years, ongoing and renewed training around human rights. So I think the recommendations that Remedy's put forward are really fantastic ones that, the government should really be paying attention to.
It's approximately 4:44 and you're listening to an interview with Sophie Ellis from Flemington Kensington Community Legal Centre, speaking about Corina Horvath and some of the serious implications of her case, and also looking at the inquiry. Now, just to ask you, Sophie, so that listeners are aware, this inquiry is an inquiry before Federal Parliament?
That's before the State Parliament.
State
Victorian
Parliament. Thank you. Okay.
Yeah.
Okay. Oh, I wish it was federal.
That's right. It's something that really should be examined in every jurisdiction in Australia, both federally and at state and territory levels, because obviously I think, it's pretty safe to say that police are getting expanded powers and, powers to use force and powers to take life. And when you're given such incredible power, there's obviously responsibility, and there's a responsibility on the state to make sure that allegations that those powers are abused are investigated properly according to international law and Australia's obligations to international law.
Let's hope that Corina does get justice. The Do and Time show will be keeping an eye on that trial, and we can perhaps talk about that once the trial is over.
Yeah.
But in terms of a best practice model, I believe that in Northern Ireland there's a police ombudsman.
That's right.
Yeah, and it's a pretty good system over there at the moment, isn't it?
Yeah, that's right. So the Northern Ireland model is an independent model where police complaints and use of complaints around use of deadly force against citizens are independently investigated by the Ombudsman.
Yeah, like there's a civilian oversight here of policing and rehabilitation, isn't there?
That's right.
Of the police service.
That's right.
Fantastic. Well, we're behind. We've got to get with the program here.
We do. And there's a lot of models, best practice shows, across the world there are a lot of models of really successful civilian oversight that have both the confidence of the people and the police. And Bonnie, the police ombudsman in Northern Ireland, annual reports, consistently show a high level of support amongst both police and civilians in how that agency is going with its investigative functions, which is really fantastic, and it's a great measure of what's working.
Absolutely. And so we're nearing the end of the interview, but listeners, just wanted to, I suppose, have listeners just think for a moment how awful it would be to have your home invaded unlawfully, to be raided, to be bashed like Ms. Horvath was, to have her nose broken and to be hospitalised for 5 days, and then for it to take approximately 18 years to have that complaint acknowledged, and it's extremely difficult, and I think that this show that we're doing now, we are very committed to having people on here who are deprived of a voice, and also speaking to their representatives and getting information out there so that people can make effective complaints. But if the system is broken, if police are investigating police, that can become doubly difficult.
Absolutely.
Do you have any final comments, Sophie?
No, other than to say, I really hope that, this inquiry, it presents an opportunity for a really robust examination into what's going on with our policing oversight and investigation system in Victoria. And, it'd be fabulous for as many Victorians who are interested to engage with it and with the report. And we'll obviously be watching very closely to see what recommendations are made by the committee, but also the government's response. And certainly we'll be hoping that the government uses this opportunity to make some real changes, which are really sorely needed. One of the big changes that is also necessary is for the state to be liable for all police tortious conduct. So, and currently, which is another point that the remedy submission made, where the state can successfully argue that the conduct is serious and willful in a civil claim, and the damages lie against the officer. So a victim will still have to pursue that officer for compensation despite a court award. And there's been some changes in that, once the victims tried to pursue, every avenue possible to get compensation and still can't, then the state has to pay an amount. But it's still not clear what that is. And, this is very reminiscent of Corina's case many years later. So many of those hurdles still exist today for people, and it's not good enough. We're hoping for some really positive changes this year. So look out for them, and we'll see how we go with reform on deck.
I hope so. And again, let's have justice for Corina.
That's right. Well, great to talk to you guys.
You too.
Thanks again for the opportunity to be on the show and chat about the case.
Thanks a lot. Take care. Keep up the good work.
Bye.
Thank you. Bye. And that was Sophie Ellis from Flemington Kensington Community Legal Centre speaking about Corina Horvath. And we actually have some current information there that there's a policeman going on trial for the unlawful raid and bashing that happened in 1996. Just very quickly, Remedy Australia is a national non-governmental, non-profit human rights monitoring organisation which believes Australia should comply with UN decisions on human rights complaints, both past and future. And they're very much into helping the UN, or believing that the UN should be more powerful. And their website, if you want to have a look, is www.remedy.org.au. And it's approximately 4:52. I'm not sure if we've got time for an announcement before we finish, Peter.
Yep, go for it.
Thank you.
Able-bodied Australia does not realise that people with disabilities across the board are being discriminated against. Then the government to demand that we go out and get a job without removing the disincentives like the lack of access to transport and community infrastructure, without providing accessible buildings that can provide barrier-free employment. I'm not getting a fair go, and I don't like it, and I'm saying so.
You're listening to 3CR, 8:55 on the AM dial.
And you're back with the Doing Time Show. Thank you to all our guests for coming in. Listen to the podcast if you missed some or all of the show. And stay tuned every Monday from 4 to 5 p.m. for the Doing Time Show. We're going out now with our theme song, Black Fellow, White Fellow from the Rumpy Band. It's goodbye from Marissa.
Thanks, guys. Have a good week.
And Beyond's you're up next.
Bye.
See you soon.
Is my commitment. On a weekly basis, I'm far from addicted. Get fueled up so I will stay alert. This is how I motivate, this is how I work. I will explain more in the second verse. There's less to hide for what it's worth. Thanks to Andrew McSweeney. How do I thank you dearly? This song is how you could hear me. Tune in hoping it's saying clearly. Now I'm in the panel running it like a pro. I am for DJ, I am for host. Give me your music, I'm willing to promote. Urban Voices is the name of my show. The sound is bouncing through.